Hello. This message is brought to you by the Contra Costa County Bar Association's Lawyer Referral and Information Service. I'm a lawyer in the San Francisco Bay Area practicing in the area of medical malpractice. I'm here to tell you about some common issues and decisions you may face if you're involved in a medical malpractice dispute. When a doctor, hospital, nurse, or other healthcare provider makes a mistake that causes injury, there may be a case for medical malpractice. Medical malpractice cases are difficult and expensive cases to win, however, and they should not be undertaken lightly. A careful analysis of the facts regarding negligence and damages should be made by a lawyer experienced in this type of case. The Contra Costa County Bar Association's Lawyer Referral and Information Service provides a panel of pre-approved and highly qualified lawyers who do just that. Gather information about what happened and provide analysis of the likelihood of a successful outcome of a medical malpractice case. It is important to understand that not all people who see doctors get well, and that not all treatment plans succeed. Further, competent doctors may disagree on the proper method of treatment, and even with the best of treatment, complications can occur. Therefore, a poor outcome does not guarantee that there is a valid claim for medical malpractice. The first question an experienced medical malpractice attorney will ask is whether the healthcare provider was negligent. To find negligence, a jury must decide that a healthcare provider did not act as carefully as a reasonably careful provider would have under the same or similar circumstances. Everyone is entitled to competent care, but not to perfect care. That your doctor did not do as well as the best doctor in his field does not mean that he was negligent. In most cases, an outside expert will have to be hired at considerable cost to give an opinion about whether there was negligence. Offhand statements by other doctors who seem sympathetic do not usually turn out to be reliable evidence about negligence. Neither do unclear statements by your own healthcare provider. Another key issue in medical malpractice cases is whether any negligence that occurred caused damages large enough to warrant bringing a claim. Jurors are usually sympathetic to healthcare providers and may not wish to punish them for mistakes that do not result in significant or permanent damages. It is also important to remember that, by definition, a person who is injured by a healthcare provider already has an underlying medical condition. Thus, an attorney advising you about a medical malpractice claim must always ask how much different your condition would have been with better care. If there is not a significant difference, it will probably not be worth the cost to file a lawsuit for medical malpractice. Information is empowering. By consulting with a competent lawyer, you can get the necessary information to evaluate your situation, know your rights, and know how to protect them. In your area, there should be a Lawyer Referral and Information Service sponsored by your local bar association. You can usually find the service in the Yellow Pages or on the Internet. Contra Costa County Bar Association's Lawyer Referral and Information Service in the San Francisco Bay Area can help you find answers to legal problems by giving you an initial consultation with a lawyer near you at a very low cost. The lawyer can explain the specifics of the law in your case and can answer all of your questions in detail. I hope this presentation has been helpful.